Good morning, everybody. It is 10 o'clock, and today we are going to do mandatory disclosure forms. What exactly are the ins and outs when it comes to this very, very important document that is absolutely something we have to do? So, as always, our favorite attorney is back, and we know that when Bruno comes, he always brings his power team with him. So, for those of you who haven't met Bruno yet, Bruno is probably one of the best attorneys in South Africa when it comes to financing, investments, structuring, tax implementations. He is your guy if you do anything property investment related. Then he's got his head of the conveyancing department, Leonora, which is an absolute superstar. And then he also has a real treat for us today, which is Marisia. Now, Marisia is a certified master inspector, and she is going to tell us everything we need to know when it comes to inspecting a property. So, Bruno, the floor is yours.
Wow. Sure. With an introduction like that, I should literally take you everywhere I go. It's it's beautiful. Thank you so much, Nadine. And it's such a pleasure to be here as always. I love these training sessions. I love working with Century 21 agents. And yeah, today it's a conversation around well, the introductions have been done, so I think this slide is no longer useful. Um, but yeah, so today we're speaking about mandatory disclosure forms. Now, the reason why we did this one is we did find that there were a lot of questions around how does it work? Does it apply to commercial properties as well as residential properties? Does it apply to leases as well as sales? So there's a lot of confusion around how it works, why it even exists, how it's supposed to be completed, and what are the implications of not completing one or having one being given to you when a mandate is going to be accepted. So just so everyone knows how we're going to set this thing out today, we've got about 90 minutes with you guys. I'm going to spend the last 30 minutes maybe just taking a few questions. If there are no questions, great, no worries. If there are questions, we're very happy to answer them. So we basically broke this down into two. So you're going to have the legal understanding the nature of the form and the consequences of the form, and that's going to be probably the first 20 minutes, 5 minutes, a bit of chit chat between myself and Leonora. Leonora will be presenting that specific part, and then after that, I'm bringing a special guest in, Marisia Robus from Gauteng Property Inspectors. Now, her job is basically to get hired out by sellers, purchasers, developers, managing agents, you name it. And she goes into roofs and she checks things out. I would actually, I'm going to give her a nice opportunity to introduce herself as we bring her on her spot. Uh, so what are the outcomes of today? It's exactly what we were mentioning before. I'm just moving the slide. Sorry, apologies. So three basic things we're looking at. How to identify issues, how to make sure that you're compliant, and how to add value. And the reason why I'm mentioning these things before we always start in a talk, I always try and get people into the right frame of mind. A lot of people have approached me and said, "Oh, but as an agent, like really, as long as it's filled in, who cares?" But there are certain things that will at some point probably be expected of agents to ask the right questions, to point out the right issues, and to guide their sellers in the right direction. And remember, this act is new. So we don't have a lot of case law. We don't have judgments that tell us how to interpret specific provisions of the act. So for now, it seems simple. The form needs to be filled in and attached to the contract. Leonora is going to go through that. But is it always going to be that simple? Are property practitioners as professionals going to be expected to do a little bit more than simply a tick box exercise? And we've seen this time and time again in our law. It's same with evictions. As an example, I'll always use this. With evictions, we're obliged to bring the municipality into the legal proceedings. And for years, we just cited them and that's it. And they sat somewhere in the back and did nothing. And as case law developed, slowly it started becoming more and more incumbent on municipalities to step in, even on smaller, less significant issues. So this adding value, an agent understanding that you're acting for a seller, but at the end of the day, you've also got your purchaser to worry about. You might get repeat business from this guy. You obviously need to maintain the integrity of the profession. And this is where how to add value comes in. This is where listening to Marisia is going to help a lot, because it's going to give you that skill set to be able to identify these things and make sure the transaction is smooth, because the last thing you want is litigation on the end of your transaction because the seller lied or misled or didn't know enough, and you as an agent didn't actually contribute to assisting the seller in that way. So we're going to speak about identifying issues, how to comply, and how to add value. So let's begin now with Leonora. Leonora, do you want to take control, introduce yourself, and yeah, take it from here?
Thank you, Bruno. Thank you, everybody. It's my privilege to be here today. So I'm Leonora, and I am the conveyancer at Bruno Simao Attorneys. So let's quickly see, Bruno, where's my slides? Yeah, me and my slides. Hello, are we there?
I am here, so you can just press next and you should be able. Okay, so I just moved your slide for you. So just take control up at the top. You can take control and just carry on.
All right, there we go. Does it show right there on your side? Okay, guys, so I was asked to talk to you about the mandatory disclosure form. We're going to refer to it as the MDF during this conversation. And my idea is actually just to bring you to the practicality about it, because I've been in practice now for 28 years, doing conveyancing for 28 years. And I've now seen how things fall apart, mistakes that estate agents make, and I would just like to guide you with this now, that you can just have a little bit more confidence and be assertive also about the MDF. So I'm not going to talk about the Property Practitioners Act. Next one, Bruno, can you just slide to the next one? Will you take control back?
I can. There is that little arrow on the bottom left-hand side where the number of the slides are, so you might just be able to click there.
I actually don't see stuff like that. I really don't see stuff like that.
Okay, no worries. Okay. I'm happy to change.
There we go. Okay, so we're gonna, let's go to the next one. Thank you. It's not my strong point here. Can you see that? So the Property Practitioners Act came into working on the 1st of February. Notwithstanding that we've had this act around for 10 months, I still get contracts that are not compliant with the Property Practitioner Act. So I'm just going to touch on a few things here that I just wish to bring under your attention, and that you can think about it. But the first question is, who needs to register with the Property Practitioner Regulatory Authority? The words highlighted here are people who, for the purpose of acquisition or of gain or remuneration. That would be people who sells, leases, or manages property, including commercial and residential. They must be registered with the PPRA. They must be in possession of a Fidelity Fund certificate. And the main word here is for the purpose of remuneration. So if you've got a developer or an investor who has a portfolio of property and he manages it himself, he collects his own rent, he does not have to have a Fidelity Fund certificate. If he sells his property privately to his tenant or to a third party, he does not have to have a Fidelity Fund certificate. The definition now of a property practitioner has been broadened by this act. And it also now goes so far to say that admin people of managing agents must also have a Fidelity Fund. Next one, please, Bruno. So while I'm touching on the Property Practitioner Act is the fact that the mandatory disclosure form is now a document that comes that's a compulsory document now that comes from the PPA now. So what's the changes, documents and certifications that has been requires changes? For example, in your contract, we no longer refer to an estate agent but a property practitioner. We don't refer to the board anymore, the EAB, but to the PPRA. The Act is now the Property Practitioners Act. And then there are certain clauses that the Act now makes it compulsory that those clauses must be included in the contract. The one that I want to point out here that I do not see in contracts, just make sure that it's in yours, is the fact that the property practitioner certifies that he is in possession of a valid Fidelity Fund certificate as on the date of the agreement. That must be a clause that must be in your contract. The right place I think it should be included is that part that refers to the agent's commission that's being earned by the contract. Next one there, Bruno. Then, so let's talk about the mandatory disclosure form. So the mandatory disclosure form should not be a new document to us. This is the old defect list. Now, some agents used it, some agents did not use it. The thing now with the new Act is it is a compulsory document. You as estate agents do not have the choice whether you're going to have one, give it to the seller, have it completed or not. It's no longer an option. Section 67 says that before you, as an estate agent, can conclude a mandate from a seller, you must have him complete the MDF form. It is officially illegal to accept a mandate from a seller or a lessor without an MDF. Does it happen in practice every day? No. I've seen it. It does not happen that the estate agent obtains the MDF, the completed and signed MDF from the seller when getting the mandate. So what happens if another agent is the listing agent and you've got the buyer? People ask for the mandatory disclosure form when you want to show the property to a buyer. So the form is quite a comprehensive list of the property's defect. And the question now is, who must complete this form? So my advice to you is that you, as the estate agent, should not complete the form. It's not your responsibility. If you complete this form, the defect list, then you are taking on the responsibility of the disclosure of all the defects. I will not recommend that. My suggestion is be assertive with the seller or the lessor and send the form to him when you do the listing and ask them to be as complete as possible with the completion with the form, that they complete it as far as possible and that they disclose everything. Now, if you look at the, I see, interesting enough, the form here that you get from the PPRA, the regulatory authority, it still refers to the Estate Agency Affairs Board. Interesting, they haven't even updated it, but this is the form that they've got there. And the form is it's not such a lengthy form, it's about 5 or 6. And it says on the form there also that if you indicate a yes to any defect, then you have to specify further. So we'll touch on that a little bit later. So the process, how the form actually must be, how you must deal with the mandatory disclosure form is that you must get the form completed by the seller and signed by the seller. So that, and you must obviously have a lot of copies thereof, so that when you go out and show the property to a prospective buyer, that you go through the property with the buyer, and then you must actually hand him a copy thereof that when he makes an offer. that he can read through the list, because that is the full disclosure of the defects of the property. So how the contract actually say, Bruno, if we can go to the next one. So in terms of the changes now to your contract that the Act now says is that the mandatory disclosure form is actually now an attachment to your contract. There must be a specific part that says, is mandatory, the MDF attached, yes or no? Because the Act says it must be attached, but that also helps for future disputes. So the in practice process is you hand the form to the purchaser already signed by the seller with the full disclosure. The purchaser must peruse it, and when he makes his offer to the seller, he must also sign the MDF, and it must be attached to the form when it goes to the seller. And that is actually the offer being made. So I'm going to talk later about the voetstoots clause, because the voetstoots clause and the MDF actually is the two that has to talk to each other, as well as other conditions in the contract. But let's first talk about the option that the buyer has. So there in the last paragraph, I'd say there that the buyer can still request an inspection of the property. So if you look at the MDF form, which the Estate Agency Affairs Board, actually the PPRA has, as well as the one on TPN, there's a clause in the form that says that the seller has disclosed everything, and then also it says the purchaser has the option to appoint his own inspector to inspect the property. Marisia will talk about that. She's the expert on that. And he will do that at his own cost. So let's ask ourselves, when will you as an estate agent advise the purchaser to do that? So let's say we know it's a property which is not in a good condition. The buyer wants to buy the property because he wants to renovate it for multi-letting, other purposes, or he wishes to flip it as a back-to-back sale perhaps. So then I would, as an estate agent, if I was an estate agent, I would then say to the purchaser, say, the property is not in a very good condition. There are some defects, as you have seen on the form, but you have the right to appoint your own inspector. Now, sometimes I would recommend that if the purchaser wants to exercise that option, I would actually put it as a due diligence in the contract as a suspensive condition. So we do training on suspensive conditions. Specifically, you will not believe it, I can actually talk an hour about suspensive conditions. But the fact is that a suspensive condition is a deal breaker, and that is sometimes when your buyer is an investor or a speculant, that due diligence clause is his exit clause if the property is not in a good condition. It gives him the opportunity to exit or renegotiate the terms of the contract. So listen to your buyer, especially if the property is an old property, a little bit dilapidated, with faults, and he says, you know what, I would like to have an inspector. Then I would recommend that you talk to him and say, okay, would you like to have it as a condition in the contract that you would like to appoint an inspector? And then I will add it as a due diligence clause. If you are uncertain as to the wording, people, wordings of contract can make it or break it. It can make that a contract can go south like you won't believe it. Wording in a contract is very important. That's why if you struggle, you're unsure as how exactly that wording must read, please do not hesitate. Please pick up the phone, phone me, Leonora, phone Bruno, or pop me an email and say, Leonora, I would like to include this condition. How can I word it? This is the intention. All right. So that is then on the option of the buyer to have a inspector to inspect the property. So Bruno, next slide. So let's talk about how the voetstoots clause. Are we there? So the voetstoots clause remains in the contract. Now the voetstoots clause will actually talk with the NDF form, because it actually says that everything that's disclosed in the MDF, the latent and patent defects that has been disclosed, is now covered with the voetstoots clause. Anything outside, should any other defect, latent or patent, come to light later on, the seller will not be liable for any repairs because he has disclosed it. The thing about the voetstoots clause is that if a purchaser wants to rely on the voetstoots clause, or actually wants to hold the seller liable, he must actually prove that the seller knew about the defect. It's a very, very heavy burden to prove in litigation that the seller must have known about it. So for example, one of my colleagues bought a house last year, December, and the seller did not disclose any defects here or there, but a major defect was the leaking of the roof. It was not leaking. It was pouring with the first rains in December when she moved in. But the interesting part is when they were actually doing the handover of the keys, the seller said to her, I'm just sending somebody out to repair a small roof leak that I've got there in the foyer somewhere. Not something major, just something small. Never disclosed it prior to that, not in the contract or anything. I just want to fix that for you, that it's nice and neat. Oh gosh. 2 weeks later, the rain came down in buckets. She showed me a video where the water was running through the downlighters. It was not a small leak in the corner. That whole roof was like a sieve. It was raining. And the seller fell back on the voetstoots clause. So she got an inspector that went in to do an inspection on a roof. It was a roof specialist. And he issued a report to say there is no way that the seller did not know that the roof was leaking. Everything shows and indicates to it that there was major roof leakings, and he did not disclose that. You see, then the voetstoots clause does not cover the seller. But what we need to remember about voetstoots, and especially the defects, people, and this is what I see when I get contracts, is that if there are certain defects disclosed, it is the purchaser's prerogative. Does he accept the property as it is with the defects? Remember, the fact that there are defects does not necessarily mean the purchaser has to accept it. So the option is, is he making his offer with the knowledge of these defects? Or is he making the offer, but he wants certain defects to be repaired? If that is the instance, then you must include it in your contract, contractually, that the seller shall repair the following defects prior to registration. So let's, for example, take damp. Roofs that leak and damp. Damp is most probably the biggest problem. And electricity, stuff like that. So if there is a damp problem, it's disclosed. And that is why, people, it's important that the NDF is completed properly, because it saves everybody a lot of problems later on. So if there is a damp problem, for example, now the purchaser sees it on the MDF because he got it beforehand. If he's got a problem with that, he has to put it at a special condition. People, you must not make this a subject, no? It's not subject to the seller repairing it. It's nothing got to do with that. It's a contractual condition that says, and this is the offer that's being made to the purchaser. Seller, we would like you to repair this damp, and I want a warranty on it. Okay, then it has to be included. Then it becomes a contractual condition for the seller to comply with.
And I think it's
Otherwise,
so, Leonora, maybe just to interrupt you, it's so important what you're saying now, because I went through a contract yesterday, also very, very similar issues, where people complete the contract and they take down a list of everything that's wrong. And it's not a bad idea to do that, don't get me wrong. And the purchaser goes in, it's like, oh, this, but no specification is made as to what needs to be done. No specification is made as to even the quality or the way that it needs to be fixed. And that's kind of the trick. I know that people joke about us being verbose and our contracts are how long, but there's a reason for that. Because when I spoke to him, I asked him, but what's your expectation on the repair? And he goes, well, it just needs to be fixed. Well, there is no just needs to be fixed. You can have badly fixed things. You can have half fixed things. Maybe you don't expect the whole thing to be fixed. Pools, for example, are you going to refiber the pool or are you just going to patch it up? There's different types of fixes. And that's something I've seen that the expectation is placed nowadays on the estate agents to be able to control this environment and broker this environment, because it's not simply a matter of, oh, willing seller, willing buyer, you two get together and fight. And then, whoever comes out, that's now the agent is expected to facilitate these type of deals. So you need to go and say, seller, listen, there's an issue here. You see that crack? That's not going to work well. Somebody's going to come in here, they're going to see it and think that you're lying to them because it's a serious crack, as an example. How do we have a conversation over fixing it? What do you put in the contract? Are you willing to reduce the purchase price or not? And I feel that facilitation role. I see Marisha's on. Marisha, do you want to add something to that? I know you do.
Yes, Bruno. Hi. Leonora, I'm so glad that you agree with me that damp is the biggest problem around. But in terms of defects to be repaired, I normally recommend to my clients, get a reduction in price from the seller, because 99% of the time, the seller is going to try and repair it as quick and as cheap as possible. And he's going to get his gardener to do the damp or to fix the roof or whatever, and it's not going to be fixed, they're going to patch it. Whereas if you say to him, listen, the damp is a 50,000 Rand problem, or if he declared the damp and it's actually worse than what the buyer thought, and then you say, okay, listen, it's actually a 100,000 Rand problem, but meet me halfway and I'll have it repaired. I'll get the guarantees and everything. So that's my recommendation because then otherwise the agent is in the middle and she or he's got to manage the expectations from the seller and the buyer and guarantees and warranties, and it turns into a nightmare. So I would just say, pass it on to the buyer. You have it fixed. Here's a reduction in price. Goodbye. Go for it.
If the seller is willing. That is why. So people, I just want to say to you there, now being dealing with this every day, it's the approach to it that's important. No? So if the property is in the market for 2.5 million Rand and the purchaser then comes and he sees the problems and everything and he makes an offer of 2 million, then obviously he's making a lower offer in light of the damages. No? Then obviously, this is me. He cannot turn around afterwards and complain about the 20 things that's wrong, because that is why the purchase price was reduced in the first place, if it was in respect of the condition of the property. So I can talk a lot, so let me wrap this up. So what I'm trying to say to you guys is that it is important that the contract, the voetstoots, the MDF, and then I'm going to touch on building plans, which is another nightmare of its own, has to talk to each other. Because if there's a contradiction, it causes problems to resolve matters and getting things done. There must be clarity. So I'm going to repeat what I'm saying now, what I said. So you've got your MDF completed exactly in what the problems are. When you give it to the purchaser, he must read it, he must sign it, and when he accepts the defaults or the defects, and does not require any fixing to it. But I must say to you, agents, you must also just tell the purchaser do you require any of this to be fixed prior to registration? You know what people think? Never assume they understand. They think, and I promise you, I kid you not, they think if you give them the defect list, it implies that the seller is going to fix it prior to registration. They just think that. They just think that. So I've had an instance where the purchaser said, yeah, but the problem was there. It was supposed to be fixed. I said, but where does it say in the contract? Yeah, but I told the agent, this stuff must be fixed. I said, but the contract doesn't say. So the fact is, and once again, I will not put in repair conditions in the MDF. Make it a contractual condition. Put in the contract there at that last clause with all the lines. Says there, the seller shall repair the following defects prior to registration. Listed. As Marisia, if it's small stuff, people, Marisia has a point there with stuff like damp and that requires certain skills and workmanship and stuff like that. I'm talking about a broken window, a leaking toilet, a cupboard that doesn't open properly, stuff like that. Listed that has to be repaired. Because me as the conveyancer, when I get a contract, I read the conditions. I see there's 5 stuff that has to be repaired. I send a mail to the seller. I say, my dear friend, the seller, there are 5 stuff for you to repair. You must please make work of this. I want this done before lodgement. Because in that time, I need the purchaser to go out to inspect it and to confirm with me that he is satisfied with the repair work. So it must be, if it's no specifications in the contract, and the contract means contractually obliged to do it, then I just look over it and I say, but there's contractually no undertaking by the seller to do it. And then the purchaser moans in my ears, but I say, sir, it's not in the contract. Please go back to the estate agent, ask him, why did he not put it in the contract? Okay, without elaborating on that. Another thing that we need to talk about is building plans. Building plans. So if I recall correctly, building plans, zoning, and all of that stuff is part of the MDF. There is a specific line that refers to it. Building plans is a major issue because the banks are getting more and more difficult and stuff like that. So let me just touch on building plans here. Some contracts, I cannot confirm whether the Century 21 has it in it, but some contracts has a contractual clause that says, the seller hereby warrants that he is in possession of updated as-is building plans. Should that not be the case, the seller hereby undertakes to make sure that the plans are updated and that they are approved prior to registration. That is in the contract. Then you send it to the seller to complete the MDF form, and on the MDF form, there's a clause that refers to the building plans, and then it's asked, are you in possession of updating building plans? And he says, no. No. I've had it, people. The file is still in front of me here. It's exactly what happened. It said no. Now the seller said, but I disclosed that there are no building plans. Then I say, but contractually, you undertook to bring it up to date. But it was never my intention. Okay, but then we have to scratch out the contractual clause, people. Because if the not updated building plan forms part of the voetstoots, the MDF saying, I'm selling this property to you, disclosing to you that I do not have updated building plans. And the purchaser does not make it a condition automatically, does not require it, then, okay, I don't want to contradict myself. If the clause was in the contract, then the purchaser made the offer with the understanding the seller is going to do it. Are you following me on what I'm saying here? Because according to law and court cases, a property that's being sold without updated as is building plans is considered as a latent defect. It's a latent defect. If it's not being disclosed by the seller in the MDF that he does not have it, he cannot fall on the voetstoots clause. All right? But if he does disclose he doesn't have it, but contractually it says he must give it, then there's no way out for the seller contractually. So building plans is a problem. We know that. Nobody keeps them. Nobody keeps it safe. And it's hard to obtain from the councils because their storing facilities and stuff is just so bad. So what happens? So I'm going to give a little bit of an advice here that I want you to exercise this. The first thing is that you have to make sure that the building plans are up to date. Number one, if the seller says, I don't have updated building plans, then you must make sure, is he selling it, disclosing that he doesn't have updated building plans, or is he willing to do updated building plans? Because actually by law, he must have it in hand. The building regulation says an owner of a property will be in possession of updated building plans. That is what the law says. So if the seller says, no, I'm not willing, I'm not spending that money, I'm not going to do it, it's going to be sold voetstoots without updated building plan, it must be disclosed in the MDF and it must be disclosed to the purchaser that there is not updated building plans. So nowadays, we've got a problem with the banks that, so I assume that when you assist the buyer with the application, you do not send the MDF to the bank. You just send the contract to the bank. So we keep the MDF close to our home. Close to us, we don't send it to the banks. I assume we don't do that. So the problem is now with building plans is that it can delay a transaction extremely. Now, my office is situated in Pretoria. The Pretoria Building Department, the City of Tshwane, is useless. 8 months, if you're lucky, 12 months for the approval of building plans, and it can hold the transaction back. So what we sometimes do is that should the purchaser come and should the purchaser insist, he says, you know what? I want building plans. I'm willing for the transaction to proceed, but I want money to be held back. The seller must pay for this building plans afterwards. Obviously, you will make the offer like that to the seller. I will disclose those building plans in an annexure, separate to the contract, in order just to avoid a delay in the transaction. To say, the parties acknowledge that there is not updated building plans. The seller undertakes he will deliver updated building plans, but the parties agree that the transaction may proceed to register and that 50,000 Rand will be retained in trust until the building plans has been approved. That way, we can have the transaction proceed, have it register, but contractually, as the conveyancer, I know I have to retain 50,000 and I have to manage afterwards the delivery of the building plans. Then it does not delay the transaction so much. So, but that's just on the sideline on building plans. But what I want to point out here is the fact that your contractual clauses has to talk to your MDF. You cannot separate the stuff. It has to talk and decide, and your purchaser must also realize that if he makes the offer with no contractual obligations for the seller to comply with any defects to repair it, that it's done. He cannot turn around later again. So yeah, is there another slide, Bruno? I think I have touched it all. Oh, that's me. That's me. Okay, I hope I haven't confused anybody. Please pop me a mail if you want more questions. I can get quite technical about that. Thank you.
Cool. Thanks so much, Leonora. So I'm going to bring Marisia on in a second, but it's things that we experience consistently every day. And there was a funny situation the other day where a person a seller sold the property to a purchaser. Agent was involved. They had done an inspection of the property in person, the purchasers had, and the purchasers had signed off the deal, made the offer. And eventually when they moved in, they saw that there was very strange things where the furniture used to be. And automatically the reaction to this was to blame the seller and say, oh, but the seller was hiding these things. Problem there was that the agent had forgotten to attach the MDF to the contract. And in the MDF, the seller had disclosed these issues. So now this purchaser sat going, hold on, wait. So these defects, I bought the property not knowing that there's defects. The seller knew that there was defects, but technically the seller disclosed it, just didn't disclose it to me directly, rather just disclosed it to the agent. The agent failed to disclose it to me. So now you sit in this little issue or this triangle of problems. And the bottom line, and I suppose this is where the wrapping up type of idea comes in, and you'll see from the outcomes that I put in the chat, what does this mean? Right? So there's good practice. This is what agents should be doing, but also what does it mean when agents don't do this? So remember, number one, you can't take a mandate without the mandatory disclosure form. You're not actually allowed to. And the Act provides for a situation where mandate's taken and the property sold, but it's not attached. That in no way is an indulgence or some kind of allowance for you not to take it. The reason it's there is because it does speak about the consequences of you guys selling a property without that form attached to it. Sure, that does not mean you're not going to get into trouble. So you might land up with a 15,000 Rand fine once off, but if you keep doing it, it starts becoming more material. 15,000 Rand fine, but with this example that I just gave you now, what lands up happening is that purchaser's coming after you. It's simple. It's pure and simple, because they're going to say, well, the seller wasn't technically at fault, but I wouldn't have bought the property if it wasn't for the agent. Transfer has now gone ahead. How am I going to fix this issue? Clear-cut fault is on the agent side. And I'd go so far as to say that if the seller tells things to the agent, that if a form isn't completed, it is incumbent on the agent to make sure that everything is done properly. So if you know of something because the seller disclosed it to you, but now you're not putting it in the form, or you're not suggesting it gets put in the form, as soon as the purchaser finds this out and starts going after the seller is going to be the first person to point the finger right back at you. Yeah.
Yeah, we must just realize that this is the MDF is not something new. We know it as an old defect list. We've always had it around. It's just become now a compulsory document to a deed of sale. As a matter of fact, I didn't mention it, it's the same with the lease agreement. Now, with lease agreements, when you take in a new lease, you should also have a MDF, and it must also be attached to the lease agreement for the same process for a new tenant. I was thinking about it, maybe if you can adjust the form a little bit, you can also use it as a entry and exit inspection list. You can also use it for that, on the tenant. But the fact is that the purpose of the MDF is to protect all parties. Full disclosure by the seller. It's the agent's responsibility to hand it over to the purchaser. The purchaser must sign it, and then nobody can turn around and say, he said, she said, you didn't mention it. And remember, the Consumer Protection Act is applicable on estate agents. That regulates the relationship between an estate agent and the seller, as well as the purchaser. So there's a lot that can go wrong for an estate agent when they do not comply with this. So basically, people stick with the basics. Make sure it's complete. Make sure what the seller disclosed to you orally has been put in the contract. Disclose it to the purchaser. One can rather negotiate around the MDF than not disclosing and have major consequences.
Absolutely. Absolutely.
Sorry, I just want to double check there. I've put in a clause in the contract. So what we've done is we've put in a clause in the contract, which you'll see there at the bottom 1.4. That refers to Annexure A, which is the disclosure form, making it part of the contract. And then we also have an Annexure B. So should there be any changes that needs to be made, it has to be on that particular form. So obviously the officers will change it depending on their type of annexure, but is that correct, or should we add something extra to that? So the contract refers to that as part of the contract, and then if there are any changes, it's a separate annexure where they have to put those things in there.
So, but It's exactly that. You're 100%. So this is a nice way of saying, look, there's a form that's attached. This doesn't mean that the person can't do inspections or anything of the sort. Now, just bear in mind as well, and I suppose this is sometimes where the kind of linear mindset needs to be given attention. If you're going to enter into a contract, you're going to have conversations around due diligences and things like that. So there's a certain way that you're going to be doing it. So to accept the mandate, you at least need the seller to disclose as much as possible. Entering and making the offer, you can then bring Marisia into the picture and say, subject to Marisia's report within X period, and her report must be a certain grade in your head. What would a positive outcome be? And that would be the next step. After that point, there can be a renegotiation. If her report is bad, it's a suspensive condition. The deal would fall away, and each party would separate. So you're looking for a renegotiation, and that Annex B is a nice way of doing it, because now you just attach an addendum and say, well, technically, here's the renegotiation. These are the expectations for the deal to go ahead, and then the due diligence is positive and it passes. But you need to kind of get your mindset right on how you're approaching it. But like Leonora said, that is such a defect is like a session on its own. We probably spend 2 to 3 hours discussing defects. Yeah, it is quite long. Cool. Marisia, sorry about that. Kept you waiting. Do you want to come with the fun stuff?
No, yeah, with the fun stuff. Okay.
Sorry, Marisa, just before you start, I'm getting a lot of questions. Guys, we're going to keep the questions till the end. So we see all your questions from Chantal and Yusuf and you guys. But after Marisa, it's going to be question and answer section. Marisa, floor's yours.
Thank you very much. I'm sure everybody has seen the little yellow finch or weaver bird build his nest. And he has no damp, no cracks, and no roof leaks. Why is that? He uses a very strict building method, which is inbred to him by Mother Nature, and he's very picky about his building materials. But in my opinion, the main reason that his little nests are so good is because his wife will rip it to pieces if it's not up to her standards. Now, unfortunately, as estate agents, you are not selling little weaver bird nests. So you have to have the mandatory disclosure form to protect the buyer, the seller, and yourself. Now, there are 4 major issues in buildings that can make or break a deal, in my opinion. The first one are roof leaks, roof defects, leaks, issues. And you must remember that roof issues are very expensive to repair. Then we have stormwater and flooding. Now, I'm actually glad that we've had a very wet, rainy season this summer and the beginning of the year, because all of a sudden people are thinking about stormwater handling. And then damp. I completely agree with Leonora. It is the biggest problem in South African houses, and it's all due to a building defect, the builders that don't know how to build. And then cracks. Now, there are 15 different types of cracks, and not all of them are serious. Some of them are just ugly, but the only very serious ones are obviously structural cracks. Now, when I arrive at a property and it's been newly painted, I go, oh no, my inspection is now going to take an hour longer because I need to find out what are they hiding. Especially if they've painted the ceilings, I know they've had roof leaks. So if you have a look at this wall, when you looked at this wall perpendicular, you didn't see all of these patchings. But look at it from the side, and the red arrows indicated where they patched cracks with polyfiller, which is the wrong product, and then they just patched the paintwork over it as well. Damp, and the yellow arrows indicate that the damp has already started to appear again. My name is Marisia Robus. I'm the owner of Gauteng Property Inspections, and I'm an NABISA certified master inspector. That is the National Association of Building Inspectors of South Africa. I'm the only female property inspector in the country. And then I'm an ITC, which is the Institute for Timber Construction certified roof inspector. I'm the only female in the country holding those two certifications. And I learned from my father. I worked for him for 10 years in our construction company. And when I started with him, he started building a house. And I went to site every single day. And he would say to me, the bricklayer is setting out the house skew. And I'm like, why? And he would explain to me, the plasterer was mixing, the plaster mix was wrong. You're going to have these types of cracks. Everything I learned from my dad on site. And that is why when I do my inspections, I do them totally differently. I don't just say, there's a crack. I tell you what crack it is, what caused it, and how to repair, not patch it. My opinion, damp is the biggest problem in South African houses. I am busy petitioning the NHBRC for them to enforce that builders must give new home buyers a 5-year damp guarantee. Because if they do that, the builders will stop their nonsense and they will start building correctly. Now, you've all seen houses like this, where the plinth, which is the bottom part of the house, the paint is peeling and it looks terrible. So that little line in the plaster there, I don't know if you can see my mouse, but that little line in the plaster there is supposed to be a joint at DPC level. So what is DPC? DPC is a damp-proof course, which is a piece of plastic, and it is supposed to protrude outside the wall 10 millimeters. Then what will happen is the damp will rise, it will hit the plastic, and it will go down. Now that joint, that line in the plaster serves absolutely no purpose, and the damp goes 1 meter high, and then gravity pulls it down. Now, the problem with damp is it is very expensive to repair because you've got to remove the plaster 1 meter high. And if the floor level is not 150 millimeter above the outside ground level, you have to dig down to the foundations, to the footings. You then waterproof the bricks, then you replaster with waterproofing agent mixed in, and then you have to repaint. So that makes it very expensive. Damp inside the house is an even bigger problem. In this case, the seller declared that this plug in the passage didn't work, and if you plugged something in there, it short-circuited everything. No wonder, look at the amount of damp in the passage, and this came from the shower on the other side of the wall. The shower was either not waterproofed or the waterproofing had failed. But if you have damp inside the house and there is no shower on the other side, then it means that the house, well, I normally find that in old houses in Melville and Auckland Park and those areas, then it means that the DPC has now already disintegrated. Then it is even more expensive to repair it. This was inside a kitchen cupboard. And when I found this damp and my buyer went back to the seller said, oh, I didn't know there was damp and mold. Well, I don't know what he did. He obviously then didn't use these plates. But the problem here was that the balcony above was not waterproofed properly and the outlet was leaking into the kitchen cupboard. Big problems, and it's a health risk. Cracks. As I said, there are 15 different types of cracks. I'm going to show you a couple of these cracks. These ones are called grazing. So they're little blocks. They look almost like countries, maps of various countries. And this is because the plaster mix was not done properly. They put too much cement in the plaster mix. And the other thing is when they plastered, they didn't wet the plaster. You must remember when you're plastering, the plaster must dry slowly. So if the wind is blowing from a specific direction or the wall faces west, the plaster must be wet before they go home at night so that it can dry carefully. Now this is called mapping. It's bigger blocks than the previous one, and you find mapping a lot on boundary walls. Now, if you have a look here, you'll see that these cracks have started to turn black. That is an indication of water ingress, and this paint has already started to lift and will very soon peel off. So again, this comes down to maintenance. The seller should have just painted over these cracks when he noticed them the first time. If you use a good quality paint, you can cover this. And once we get to these types of cracks with the weeds and the plants and the garden growing into it, you've only got one option, and that is to remove all of this plaster. This is a structural crack. As you can see, the steps going up to the front door were moving away from the house. This is serious. And in this case, the seller did not declare it. And when I asked, how long has this crack been like that? He said, no, I've never noticed that. So that's rubbish. So my advice to you as agents is also have a look around. If you see cracks like this, say to the seller, disclose this crack. How long has it been here? And it's very clear to see that it is a structural crack. This house was a disaster. It was built on a slope and it had so many structural cracks. You can see the position of the red arrows. The building was moving completely to the right and was going to slide down the hill any minute. This crack actually went up through the floor into the kitchen, and it actually cracked one of the kitchen cupboards in half as well. So this is serious. Have a look for structural cracks. Now, this client bought this house and it was beautiful. A new main bedroom and bathroom had been added, and within 3 months, this huge crack developed. I did an inspection, found that the foundations were not sufficient, and when I asked for the approved building plans, because my advice to my client was to sue the engineer who signed off the foundations and have it repaired under his professional indemnity, there were no building plans. But because it was within 2 years of the purchase and the transfer of the client, of the property, my client could reverse the sale because the seller had sold him a fraudulent property. So my advice is have approved building plans available. Leonora gave you a good option on how to get the plans approved a bit later, but still let the transfer go through. And Bruno has actually drafted a clause for me, which I give to my clients to say, this is what you put in about the building plans. But there's something I want to add on the building plans. The Splumer Act and the building regulations very clearly states that if you have done alterations or you've built a new build, you have to get an occupancy certificate. Now, for an occupancy certificate, you need an engineer certificate for the foundations, for the first floor slab, if there is one. You need to get one for the roof, be it a roof slab or trusses. You need glazing, which is the glass, electrical and plumbing. So if a seller must have building plans approved and there were alterations done, I strongly suggest that you request that an occupancy certificate is issued as well, because now you have to get an engineer who has to come and inspect foundations, roof slab, trusses and everything after the fact, and he has to sign it off. So instead of you charging you the normal 8,000 or 9,000 Rand, he's going to charge you 15,000 to 20,000 Rand now to issue those certificates because his professional indemnity is on the line. Roof issues are very expensive to repair. And as Leonora said, it is very clear when there has been previous roof leaks and the seller just didn't disclose it. In this case, the seller said that he had a small roof leak and he's repaired it, but it still sometimes leaks a little bit. When I climbed on top of the roof and found this, it was very clear why the roof was leaking. And this is not how you repair the roof. This is how you patch it. There were roof leaks in this garage below this roof, and it's very clear why. They had started a compost heap on top of the garage roof, and the sheets were severely rusted and water was leaking through. It's very important that things like this are picked up. When I do inspections and I find something like this, I inform the estate agent and not just my client, because I say to them, please get the seller to clean this roof or the gutters before the transfer goes through, because transfer might take another 3 months, or my client might not buy the property and the damage is going to be even worse. The waterproofing on this roof had to be redone completely. You can see how the water was ponding on it, and they had roof leaks below. Now this is serious, the roof trusses. I know you don't climb into the roofs. I do. This is a king post, the main post of the roof trusses, and this was in an office block. The minute I put my head into that roof and I realized that this king post had completely pulled out, I immediately informed the owner of the building and said, you have to evacuate this building immediately, come and put supports in under these roof trusses and repair this roof immediately. They evacuated the people, but they took their time, and it took them about 2 days before they came and fitted supports, at which time 2 of the roof trusses had already collapsed. So that is a serious, serious problem. Now, on office blocks, commercial and industrial properties, you are supposed to have a roof inspection done annually. So if you are selling commercial or industrial properties, ask the seller for his roof certificate. The roofs have to be inspected annually. Also, in that case, the client, the seller, had not had his roof inspections done regularly, and insurance declined his claim. So he was sitting with a huge repair bill. This was a bad one. My client asked me to do a maintenance inspection for him. When I fetched my ladder to climb into the roof, he said, why do you want to climb into the roof? I said, I need to check what's happening with the geyser and if everything is okay there. I climbed into the roof to find brand new under-tile plastic and scorched roof trusses. And the burnt under-tile plastic was lying in the bottom of the roof. It was filthy. So I asked my client, when did the roof burn? He said, no, there was no fire. I said, well, this roof recently burned because that plastic was still very, very new. The seller, unfortunately, had immigrated to New Zealand, but he contacted the agent, who was an agent in that area for 15 years. He asked her, so when did the roof on this house that I bought from you last year, when did it burn? And she was, oh yes, I think there was a fire in the area in the last 3 years. Oh, it might have been that house. That's not on. That's not on for that not being disclosed. This was unfortunately before the mandatory disclosure forms, and my client had to foot the bill. He actually went back to the insurance company who repaired this roof because there were 4 roof trusses that had to be replaced still. So that is why it's important to get everything checked out. Now, another big problem, and I'm not sure, I forgot to check if it is on the mandatory disclosure forms, is asbestos. The Asbestos Abatement Act came into effect September last year, and by, I think it was the 8th of May this year, everybody was supposed to submit a inventory of all the asbestos on their properties with the condition of the asbestos as well as what their asbestos plan was. Now, the government realizes that they cannot force people to remove asbestos roof sheets and ceilings and everything because it's normally in the older areas and it's very expensive to remove and replace asbestos. So they have now said if you have a registry, if you've submitted you're registered to us and your asbestos is in a good condition and it's painted, it is okay, you can keep it. Now, the problem with asbestos is that Everite stopped manufacturing asbestos in 2003, but they had enough product that they could still sell all asbestos products until 2004. But the problem is that they then, the big retailers, imported cheap asbestos products from Zimbabwe until 2008. And until 2009 and 2010, there was still a lot of asbestos products sold in South Africa. So only if your house was built after May 2011 can you be sure that there is no asbestos in it. So where do we find asbestos? Roof sheets, carport sheets, ceilings, window sills, fascia boards, and then also the eaves outside where your exposed roof timber is, that is normally closed by asbestos. So please ensure that your sellers declare their asbestos, and my recommendation is that they have the asbestos register done, have a plan done, and then sell it with it. To do an asbestos plan on a normal 3-boy bedroom house is about between 3,000 and 5,000 Rand. So you can contact me, I'm an asbestos inspector, and we can assist with that. Now, the other thing that people don't realize is that insurance declines your claim if your house is not built according to building regulations, or if there's a list of things that they will not pay for. So what are some of the things they will not pay for? Insects. Can you see these holes on the sprocket, the exposed roof timber? And the bottom part has become totally rotten and brittle and was falling apart. Now, these are carpenter bees, and they're crafty little fellows. They will burrow into the wood a small distance, turn 90 degrees, burrow a little bit more, then turn 90 degrees again, and they create a complete maze inside the timber. Yeah, I caught some of them in action. On the top photograph, you can see one's bum sticking out, and the bottom one was busy excavating. Now, this is a problem because this timber was painted. Now, paint does not repel carpenter bees, termites, and you also get the borer beetles. But if the exposed timber is treated with carbolinium or creosote, that black stuff that stinks, it repels the insects. These are termites, and they've been quite active this year. Once you've got termites like this in your house, you have a big, big, big problem. They normally start on the grass, and ask your sellers, have you had termites on your grass? Here they moved onto the pole of the patio, and you can see that this pole that was holding up the patio roof was totally unstable. And from here, they move into the house, into the skirtings, and into the roof trusses. Once they're in the roof trusses, you have a major problem. There must be a firewall between the house and the garage because regulations accept that you store chemicals and flammable stuff in the garage, and the regulation states that you must have a 30-minute fire door between the house and the garage and a firewall. So if a fire breaks out in the garage, it will not spread into the house quickly. This was illegal because these roof trusses ran straight through from the garage into the house. So if a fire starts in the garage, it will be into the house in no time. These people, these sellers, bricked off a part of the garage during COVID for a study, but they also didn't build a firewall. This is what a firewall looks like. So you've got the roof truss on this side, the firewall, and then you've got the roof trusses continuing on the other side. Very important, this. In this case, the seller declared that they had moved the geyser to be more central so that you didn't have to wait so long for the water to get to the kitchen and it wouldn't take too long to get to the bathrooms. But nobody went and checked what the plumber actually did in the roof when he moved the geyser. So the yellow line indicates where there was supposed to be a web of the roof truss, which the plumber promptly just broke out so that he could fit the geyser in. And now on top of it, the geyser was resting on top of this roof truss, which he has now weakened. And the problem here is when, not if, when this roof truss fails, insurance will not pay. Another problem are balustrades. So the law states that the balustrade must extend the full length of the staircase. As you can see, this one did not extend the full length. And then the openings in balustrades. So the law says that a ball with a diameter of 100 millimeters shall not be allowed to pass through. In this case, the opening was almost 20 centimeters. The reason for this is that a small child can fall through the balustrade and get hurt. And especially if you are renting properties out, you as the landlord will then be in problems. So when I do my inspections, I color code my reports. So the red captions is if something is broken, or it is not done according to regulations, or it is a health or a safety risk. So the balustrade will be a safety risk. A health risk will be a leaking sewage pipe. And I would normally tell the agent, or if the seller is there, tell them, listen, I found a leaking sewage pipe. I strongly suggest that you have it repaired. The blue items are items which must be attended to before they become red items. Items such as these are gutters and valleys that are full of leaves. Just before the rainy season, people must clean their roofs and gutters, but they don't. And I find a lot of times when I say to the seller, listen, your gutters are blocked. When is the gardener coming again? And he says, but he was here on Monday and he cleaned the gutters. I know he didn't. The gutters are so full of leaves and sand and everything. So that is the thing that you must attend to it before it becomes a red item and must be replaced. And then the green items are purely maintenance items. I find that people don't know how and when to do maintenance, and that is what I want to teach them, that they must make sure they know how and when to do maintenance. Now, what I tell my clients, obviously the red items are the serious items, and they can then decide if the items are really severe and they don't feel like repairing all of this, they will walk away from the deal, or they will renegotiate and say to the seller, listen, I found this, can you repair the sewage pipe, can you do this, clean the gutters, whatever the case may be, and please give me a discount so I can go and repair the damp. And as I said before, my recommendation to my clients, get a discount from the seller and repair these items yourself. It's a lot easier on everybody, on the seller, on the agent, as well as on the buyer. And the buyer can decide, does he want to get the best company to repair it and pay top dollar? Or does he want to get an okey poke standing next to Builder's Warehouse to patch it for him? And then if it's not fixed, it's his problem. It's not the seller or the agent's problem. I really do believe that as an agency, you will benefit from our services, and your sellers and your buyers will benefit as well. I also offer a service where I will walk through a house with an agent and the seller and point out various things to them. So there's no photographs, there's no reports. I will say, listen, that cupboard door is hanging. It's easy to adjust the hinges. Do this, it will look better. Here's a leaking sewage pipe, repair this. The gutters are dirty, clean them. Just point out a few things like that. For that, I charge 1,500 Rand. Then I do full property inspections where I look at everything from the gate to stormwater to the boundary walls. I climb inside the roof, on top of the roof. I open all the cupboard doors. I flush the toilets. I see if it leaks under the zinc and the vanity and everything. Or I do a basic essential inspection where I only look at the 4 big things that can cost you money: damp, cracks, roof, and stormwater. And then I do single inspections, just damp, just crack. I did a tree inspection once. The client was concerned, was this tree too close to the house? Were the roots under the foundations? So whatever your client, your buyer or your seller needs, I'm available to assist. And a very good way that sellers have been using my reports, let's say for instance, they want 2 million rand for the house. I come in and I do an inspection and it's color coded like that. And then the seller decides, oh, but I'll repair the leaking sewage pipe, I'll clean the gutters, whatever. I then go and check, take it off the report. And then the seller says, listen, I wanted, let's say, 2.2 million for my house. Here's a report. I'm not repairing these items. I'm selling the house with the report. I'll now take 2 million. And in that case, the house sells a lot faster because the buyers also feel much more confident. Thank you.
Well, thanks so much, Marisia. I always love listening to you. A bit scary, but always fun.
Good.
I'll take control now. Okay, guys, so it is the time for Q&A. So I've just got the holding slide that we can put in here. So it's Q&A time. I did answer some of the questions in the chat, so hopefully that yes, some of you guys did get the answers you want.
Sorry, you just froze for about 10 seconds.
Oh, no worries. So yeah, I was just saying it's time for Q&A. I did answer some of the questions in the chat. But yeah, let's any questions that you have now, please feel free to ask. While you guys are listening or asking questions, please feel free to scan our QR code to let us know what you thought of this, whether it was helpful, if you have any insights, preferably positive, but if there's negative, let me have them too, or contact me and give me some feedback. I always love to hear it. And if you do need to contact us, our number is there. And Marisia's Marisia's website is there for you guys. But yeah, Nicolene, it's all yours.
All right, so the first thing, that was freaking brilliant. I loved every minute of it. Marisia, so interesting. And I almost think that, guys, this would be almost, I think, in future, I'll probably say this has to be a must, because me as an agent, I wouldn't know what to look for. I can point out the obvious things, and how about we give it to someone else that is a pro at it, that would be able to give your sellers and your buyers a peace of mind. So definitely look into that. It might be a very, very good thing. The second thing I wanted to say is Marisia mentioned the fact about asbestos. And that it has to be declared. How about you guys make that a value add items for your farming areas and inform your buyers and sellers of this, because this is not something the average person would know. And then we have a question from Chantal, and Chantal asked, what about a cash buyer? The seller noticed after signing the contract that the domestic room was never added onto the plans when the house was built 14 years ago. The purchaser hasn't asked for the plans, and the deal is about to conclude within the next couple of weeks. How do I handle this not to create a dispute between both parties?
Sure. So I did put a short little answer. It comes down to the content of the contract. So that's the one thing that you always need to look at first. It's crucial because the contract would dictate whether things like voetstoots apply, whether the seller did disclose that there were issues that they weren't aware of, whether they discover it or not is inconsequential. Also questions when it comes to like CPA, for example. So Leonora touched on it, but there's a very simple way of looking at things. If you're a private seller, the CPA does not apply between you and the purchaser. If the CPA does not apply, things like voetstoots count, right? You're good with voetstoots unless you're lying. So lying is always bad. Voetstoots does not protect a liar. If the CPA does apply, then whether you're lying or not, defects are bad. So either the lying's bad or defects are bad. And in the case of a CPA, even if you didn't know about it and you're a bona fide purchaser and you just discovered it, doesn't help, because a consumer is entitled to defect-free products. So bear that in mind. That's kind of like the ground rule on which us as attorneys approach everything. So now the interesting thing with this question is the timing. So you have different timings when it comes to property transactions. You have the date that the contract signed, you have the date, and then you have the date of transfer, right? So in between these two dates is this very strange abstract period where you're trying to move as quickly as possible and you're hoping things don't happen during this period, because ideally you'd want the position as at contract date to be the same position as at transfer date, and that doesn't always happen. Things like occupation, issues with occupation happen during this period. New damages, vandalism, a whole range of things happen during this period. In our law, we work on a system of law where the only time ownership only passes upon delivery. Delivery in our law is symbolic. Deeds office constitutes delivery because it's literally the title deed in one person's name moved over to another person's name. So as a legal concept, it's delivery. So up until delivery, the sale is still going ahead. So yes, you might not have known about the building plans issue prior to entering into the contract, but you definitely did know about it prior to delivery of the property. So unless your contract states otherwise, where the property is going to be sold irrespective of building plans, there would be an obligation, unfortunately, on the seller to disclose this to the purchaser. And now that you as agent know this, it would be incumbent of you to disclose it.
All right, a very, very good question from Dion. And he says, when the seller has a representative, can the representative fill in the MDF, or must it be done by the seller owner? And is it okay to fill in the MDF in with the seller's representative by means of virtual meeting and then send by email and then sign it?
That's actually a very good question. So breaking up into different components. So does the seller himself have to sign it? No, no, they don't. And if you read section 67, it specifically provides for the mechanisms that have to be followed if there's a representative, because now the representative is going to warrant in his own name. There needs to be confirmation from the seller that this is in fact his representative, and everything needs to be in writing. So yes, a third party can do it on behalf of the seller, representing the seller, but there needs to be some sort of confirmation from the seller that this party is authorized to do so. So that is okay. Now, whether it can be done virtually, well, so I suppose the thing is filling in the form can be done virtually. No one's ever stopped it from being done virtually, right? The bottom line is, as long as it's attached to the contract, you can fill it out virtually. Now, the question on whether it needs to be signed virtually is an interesting one. Leonora might have a different view. I've never encountered that question. In my mind, it's yes, it forms part of a sale agreement, which always has to be in writing, but it's not specific to the sale, it's specific to defects. So arguably, as long as the sale agreement is in wet ink, so basically signed by hand, I would say that the form could probably be a copy, a photocopy. I would still play it safe and have it as an original, but if you really, really can't, I don't think it would be against the Alienation of Land Act just for that one disclosure form not to be the original. But Leonora, I don't know if you share that sentiment.
Yes, Bruno, I agree with you. No problem with the form. I think because it's a form by the Property Practitioners Act and not one that is in terms of the Alienation of Land Act.
Sure.
So I agree with what you've just mentioned.
Sure.
I just also want to mention I agree. I was very pertinent when I said the seller must sign it, but yes, there is the option that a representative, but it's all about having knowledge about the property. You understand? Obviously, if I go and if a seller asks me to go and complete a MDF and I've got no knowledge of the property, then I really don't think that's a wise thing. So obviously it will be with the information provided. But when there's a tenant in the property, I was thinking about that. I mean, estate agents will agree. If there's a tenant in the property, you don't take a prospective buyer to view with the tenant in the place, because that tenant will say, oh, that thing is broken and that thing is broken and that thing is broken. So that's your best guy to complete the MDF form for you, because the tenant will know more about the property than the registered owner because he lives in the property. So maybe that is also an option, in the sense that being an occupant for 6 months or a year or so on, I will perhaps it's an option for the tenant to complete it with the instructions, because on the MDF there's actually the clause reads that the person completing this MDF form has authorization by the seller to do that. I cannot repeat, I'm not sure whether it's in writing or not, but he is authorized. So just get the authorization from the seller and say, listen, Mr. Landlord, you're far away. Your tenant knows this property. Can your tenant complete it? Because it's about honesty, transparency, and disclosure. Now, that's what it's about.
Absolutely.
Definitely.
Absolutely.
So, but definitely agents, you do not fill it in on behalf
Yes.
of
No.
the seller.
Yeah.
No
No.
way whatsoever.
Yeah.
If they need someone and they are out of town and they can't do it themselves, then get a Marisa to do it, outsource it, but you do not do it.
This,
Nicoline?
it's
No
just so
buts.
funny watching Nicoline's like lawyer, legal hat, like, no, listen, that's great and everything. You can do it, just not here. Ever.
No.
Nicoline, just something on the asbestos. It's, I did a roof leak inspection in Northcliffe on Monday. And as I walked through the house to go to the front to climb on top of the roof, I said, oh, you've got asbestos ceilings. And she's like, oh, I do. So it's, as I say, if the property was built before 2011, you've got very good chances of having asbestos. And maybe I can do an asbestos training course with your agents at a later stage and just give you a bit of more guidelines on the asbestos.
That would be absolutely brilliant.
But in the meantime, if you've got properties that have got asbestos or you think they have or whatever, contact me. We've got asbestos inspectors right across the country, and we'll put together the plan and everything, and it's not expensive, and then it's legal. And it's another thing that you as an estate agency group can offer and say, listen, our properties are sold with all the asbestos regulations in place.
That would be great, because that's not something that the average person, because I'm in property and I'm thinking, I'm wondering if my fascias is the asbestos. Now that I'm thinking, it probably is. So I would have to go and do that. But
and also windowsills.
That could also maybe be.
Yes.
That could also maybe be. So any other questions, guys? I find this so fascinating. What do you guys think? Do you want Bruno and Marisa and no, what did I put a name? And Leonora, do you guys want them to come back? How awesome are they? I see that I have a hand for Manuel and Jerry. So Jerry, I'm going to open your mic. Allow mic. Okay. Jerry, are you there? Jerry, you'll just have to unmute yourself and then you'll be able to chat. And then I'm going to do the same for Emmanuel.
Hi, everyone. Can you hear me?
Yes, Jerry, we can.
Hi.
Hi, Nicoline. Nicoline, the auction part that we've put in place, how does that affect this whole inspection and voetstoots thing? Because most of the auctions that I've been to, you buy what you get, and they don't care if the foundation is faulty or whatever. They don't disclose it. They just say this is what that's on the market.
Okay,
So
remember what
how
the
do you
law
handle that?
says. The law says all properties, regardless of what. So you either have to do it with a rental for a rental. Just want to reinforce that with you guys. All your rentals must also have a disclosure form. A disclosure form is not an inspection form. Your inspection form is still separate. You still need to do an inspection form, but a disclosure form goes with the lease agreement. So, Bruno, do you want to handle that one?
Sure. Okay. So if I understand the question correctly, we're referring to why auctions appear to work under different rules than your normal private sales, right? Why people can walk into an auction and they buy as is, and the auctioneers throw their hands up and say, well, we don't care. That's the way that you bought it. Look, so that is definitely the perception that exists. I think the perception is also, it might be a little bit skewed, especially because of the way sheriff's auctions are conducted. So remember, sheriff's auctions do have a different set of rules, because it's not just about facilitating. Sheriffs are officers of the court. They're there to execute a particular task, which happens to be the selling of property, whether it's movable, immovable. So to a certain degree, you'd expect that they would comply with the same sort of laws or regulations for estate agents, but it's not their primary function. Their business is not the sale and brokering of properties, even though they make money from it, and they're guided by different pieces of legislation. And when you're trying to foreclose a property, it's known and it's very well disclosed in terms of those pieces of legislation that the sheriff has no clue what the condition of the property is. And that's why, the properties sell for the prices they do sell. Now we move to private auctions. So private auctions, and there's no reason why the same rules don't apply, and they should. And if you see that they don't, then something's definitely going wrong with that auction. Yes, even with private sales, bear in mind that you can get away with a private sale in terms of the Consumer Protection Act by the property being completely dilapidated. If the purchaser walks in and he sees that the property is in a terrible condition, he doesn't have protection in terms of the CPA simply by virtue of, oh, but I'm a consumer. So if you contract properly to say, listen, but these are existing defects, you're undertaking these obligations. We're not hiding behind them. And there's a big difference between having open, transparent disclosure and a voetstoots clause. And I think that's sometimes where we miss the boat. A voetstoots clause the consumers don't often know what they're getting. It's inserted in there. They don't understand it. They read it, they sign it. They didn't get what voetstoots actually meant. If you disclose every defect word for word and it's expressed and you initial next to it, you can't use the Consumer Protection Act to try get out of the contract at a later stage. So how do private auctions do it? They have to be open and disclose what the issues are, or why the auction's being done in a very particular way, and why people are undertaking this risk. And you as a private person can do the same. Just needs to be very open that they're undertaking this risk simply because there's no way that you'd ever know what the defects of this property are.
So in our auction division, they have to also do the mandatory disclosure form. So our auction division, as private auctions, they have to do that. So whenever you deal with Yakov or Anita, they will also ask you for the disclosure form. That has to be there. Remember, it says all properties.
Yeah.
All properties. So remember
Totally
for your
agree.
rental as well. Okay, we're going to have 2 more questions and then we're going to end off because we are a little bit over time. So I'm just going to quickly open the mic for Manuel. Manuel, you can unmute yourself and ask us your question. Manuel, there? Okay, let's move on then to Charmaine's question. Just remember, Chantal, Marisia did answer your question on the roofs in the chat box for you. So Charmaine says, we had a matter where the seller's attorney amended the contract as the seller was living abroad and did not want to take responsibility for the defects as he did not have knowledge thereof. The seller also did not want to appoint the tenant as a representative. How will this impact the liability of the agent that the contract was amended and it was not completed? They said in the contract that the purchaser had to do an inspection of if they wanted to.
No, that doesn't sound right. And there's multiple facets to this. So a seller can be abroad, but the seller would then still be incumbent on making sure that either from abroad they disclose what they know the defects to be, or they appoint someone to verify what the defects could be. And they would then, submit this to the agent. So agent cannot take mandate without that disclosure form. So that's already the big thing. So by the time it gets to a conveyancer, I have to ask what happened with the conclusion of the contract, because we've just missed the whole step. What happened with the giving of a mandate, conclusion of the contract? Because now we're at conveyancing stage where they're amending an existing contract. And the amending is also, it's a bit difficult. Number one, you can't amend a contract without both parties signing. So the seller's attorneys have no rights or power to amend anything, right? They would need both parties to sign. And what are they amending? Are they adding defects or they minusing defects? Because if they're adding defects, then the purchaser now has a glorious opportunity to identify this and go, oh, okay, well, there's an issue with this. Do I agree with it or not? So Nicolene, maybe just let me know, does that kind of address the question, or?
Charmaine just added, it was amended before signatures.
All right. But then both parties would have had the opportunity of reading the contract.
Yes.
Yeah, okay.
Yes.
So there wouldn't have been any surprises. The attorney can amend whenever, on whose ever instruction. I suppose what's the content of the amendment? Is it to say that the property is sold voetstoots and it's incumbent on the purchaser to inspect the property? Because honestly, I could draft a contract very easily to say, look, guys, I'm abroad. I don't know what this property looks like. And I did it for a client the other day. And it was actually quite a sad story. So the client bought the property on auction, resold it, but he resold it during winter when it wasn't raining. But we were very express that we have never lived on this property. We bought it on auction. We don't know anything about it. There might very well be defects. You are buying this at risk. But continue anyway. It's completely up to you. The purchase price factors this risk component. And unfortunately, when summer came, the rains came. It was at the end of like a cul-de-sac. So it completely flooded, water in, foundations. It was a disaster. Like the bottom floor completely flooded, and you could see that there was going to be defects here and damage to foundations. But the client was protected because of the transparency. He didn't just hide behind a voetstoots that no one understands. It's more about the fairness. Everyone will sign a contract, there'll be a voetstoots. I mean, how many things do you guys sign on a daily basis where you just accept terms and conditions, accept terms and conditions? That's what the CPA is trying to avoid, is you can have whatever terms and conditions, but if no one's reading through it, then they don't count. And that's kind of how the CPA looks at it. So if you want something to be very apparent, make sure that people initial next to it. Put a little speech bubble, and it's like the plain language movement. So you'll see on some of my contracts that are very consumer orientated, I've got little speech bubbles or a picture of someone saying, oh, this is what it means, just so people can understand it, because then they can't argue that they didn't understand it. Whereas if you have old school contracts where it was a 30-page contract drafted by me, then people very easily would say, sorry, you know what, I'm not going to read this. I've got no idea what it said.
So just to be clear, there has to be a disclosure form. Not putting in a disclosure form is stating that everything is in order.
Yes.
And if there's any defects in that case, the seller will be responsible for it. All right?
Yes.
So what is the liability on an agent? So the agent told the seller, you have to put the disclosure. The seller refuses to do the disclosure or to get a representative. Is there a clause that we can put in to say, I was informed that I have to put in the disclosure form to protect the agents, because you are going to get those difficult sellers that are just going to absolutely refuse?
Look, it's a tough one. I've been getting this question quite a lot, especially in the commercial space where people are trying to sell businesses with properties attached to it. The problem is that the Act's very specific. It says, do not take a mandate without a disclosure form. Don't, right? If it does happen, there's going to be punishment. It doesn't impact the validity of the agreement. So the agreement can proceed, but there will be punishment on the agent. You will be fined. And now the main consequence, and all this entire conversation that we've been having around CPA and voetstoots and defects, all of this, we said, well, the seller might be liable for these damages if X happens or if Y happens. Now imagine that not only will the seller be liable, but so will you as the agent, because every right of recourse that we spoke about today that might be against the seller it can be used against the agent as well, if they did not insist on the mandatory disclosure form being completed and attached. So that's opening yourself up for liabilities, repair of defects, etc., etc.
Okay, so in other words, guys, you are not, it is illegal for you to take
Yeah.
a mandate without a disclosure form. So therefore, you cannot say the seller refused to sign it because you were never supposed to have that or to take that mandate in the first place.
Yeah.
So it is becoming a bit difficult for us, but we need to walk the line and do things right. Okay, guys, our time is up. Apologies for running about 10 minutes past. Bruno, Eleanor, Marisa, you guys were absolutely brilliant. We are definitely having you guys back. Also, is there any rental agents online today? Just give me a yes in the chat box. Any rental agents? Yes, quite a few. So Bruno is playing with a suggestion to maybe once every 6 months or once a month have a 30-minute troubleshooting rental session where you guys can come in and ask him whatever you want in regards to rentals. Is that something you guys would go yay or nay for? Oh, I got an awesome. Yes, yes, yes. Okay, so
Cool.
that seems like something that we would be going into that.
Yeah, let's
Awesome,
definitely do it.
perfect.
Yeah.
Guys, we absolutely appreciate all three of you. You guys are absolutely brilliant. Your knowledge. Wow, Marisa, you just know what you're talking about. You ooze knowledge. It's absolutely brilliant. Same with you, Bruno, and same with you, Leonora. We absolutely appreciate you guys. You guys online, thank you so much for joining us. We appreciate your time and we hope you learned a lot. This recording will be available on the university in about 2 weeks' time. Please remember, if you have any questions, Bruno's details are on the screen. If we could, Marisa, do you just want to repeat your email address for us?
Yes.
So there's the
you can
site.
go to my website, gautinginspect.co.za, and then you'll find my email address, my telephone number, or you can just submit a query there or anything. That's the easiest.
Brilliant. Guys, have an amazing week.
Cool.
See
Thanks
you
so
guys.
much. Thanks for having us.
Thank you very much for having
Cheers.
us. Bye-bye, everybody.
Bye.